practices on Long Island and in North Branch. My practice area involves wills, advanced directives, guardianships, supplemental needs trusts, and Medicaid eligibility planning and applications, as well as residential real estate closings. My background, just to tell you a little bit about myself, I'm a graduate of Stuyvesant High School, the University of Pennsylvania, and Brooklyn Law School, which I attended at night for 4 years while working as a legal assistant. I love what I do, and my mission statement is to provide high-quality legal services to everyone, regardless of their income and resource level. I do this by means of reasonable rates and clear communications. I don't like to use fancy legal jargon, and I feel it's important for my clients to understand sometimes complex legal issues. As Zahra said, we're facing unprecedented challenges today, not only in our personal lives and curtailed personal freedoms, but there are dramatic changes to the law. I'm only going to be discussing changes to New York State law as they impact my practice areas, and some of them are rather significant. Some are permanent and some are temporary. With respect to recent permanent changes in New York State law that affect the field of elder law, as a result of the newly passed New York State budget, there is now a 30-month look-back period applicable to community Medicaid applications. This means that if a client comes to me and feels that they would like to render themselves eligible for Medicaid benefits to help pay for the cost of a home care attendant, Social Services is going to look back at their whole financial picture for 30 months, that's 2.5 years. And if transfers have been made for purposes of Medicaid eligibility planning, that client will not be eligible for home care assistance paid for by Medicaid for 2.5 years. What does this mean to us? This means that there is a greater need now than ever before for advanced planning for Medicaid eligibility. If you have not yet planned for this, I strongly urge you to see an elder law attorney as soon as possible. These changes to the law, I must say, are not effective until April 1st of 2020, but that's really just around the corner. There are still ways to make yourselves eligible for Medicaid, and most people need to in the United States. Although Medicaid was initiated back in the 60s to help indigent people have medical insurance, today the costs of aging, the medical costs of aging with respect to home care and nursing home care is so terribly expensive that many people find a need to apply for Medicaid benefits to pay for these services. The other permanent change to the law as a result of the new budget has to do with the way Medicaid assessments will be made. Rather than having private long-term care insurance companies determine the level of disability of a client or the number of hours of home care that will be provided, soon, as of October 1st, the Department of Health instead will be making these decisions. With respect to emergency changes to the law that Governor Cuomo has instituted, one is that's very, very important is you should know that all statutes of limitations in New York State have been tolled. Currently, I believe the statute of limitation toll expires on May 7th. It's very likely to be extended. This means that if you had to initiate a lawsuit by a certain date, but you couldn't because the courts were closed at the end of March and still are due to the COVID pandemic, you do not lose your opportunity to pursue that cause of action because of a failure to meet the statute of limitations. They have been told, which means they will be extended. It's very important also for you to know, if you don't already, that the court system in New York State is virtually closed. All types of courts for all purposes except for emergency matters and certain pending matters which are non-essential but which we began and had progressed along well along the way prior to the closure of the court systems. One way that this affects me in my practice, I do a lot of surrogates court work, not only estate and administration proceedings, probate proceedings in surrogates court, but also litigation. There are no new matters being entertained currently in the surrogates courts. The only estates that are being opened now, as far as I know, and this is very current information, are if an estate needs to be open in order for an executor or administrator to be appointed to gain access to the decedent's funds to pay the funeral director. Other than that, no new estates are being opened currently. There are other temporary laws that have been imposed as a result of the pandemic by means of executive orders, which were signed also by Governor Cuomo. And the main two that I'm aware of that affect my practice area are, number one, notarization may now be conducted virtually. So if you need a document notarized, rather than having to go to the bank or to find a notary somewhere else, you can now contact a notary and have them notarize your signature by means of a digital platform, such as the one we're on now, like Zoom. There are a lot of limitations to how this can happen, but it absolutely can. It requires certainly that both the notary and the client have some tech capabilities, because the document has to be scanned by the client to the notary for them to notarize it. There must be real-time interaction between the notary and the person who wants a document signed. And the person who wants their document signed also must affirm to the notary that he or she is within New York State at the time this is happening. The other executive order that touches on my practice area has to do with remote witnessing. Certain documents that I prepare for clients, last will and testament, and advanced directives, like a living will, healthcare proxy, normally the witnesses must appear in the same room with the supervising attorney and the client to witness these documents. However, thanks to these executive orders, remote witnessing by video platform is now a possibility. There are ambiguities in the law, and it can be difficult for clients, particularly older or physically challenged people, to meet the criteria for this virtual witnessing. However, it can happen. Other options that my firm offers are open air or curbside will signing ceremonies. So what this means is, if everybody practices social distancing and wears a mask and gloves, we can get documents signed, essential documents signed, without having to require that a client has access to a scanner and other technology with which they may be uncomfortable. Another topic I wanted to address was special tips relevant now during this pandemic to caregivers and people who you may find yourself alone. Today, you may not be aware that visitation in hospitals and nursing homes is temporarily not permitted in New York State. I'm not sure about other states, but I know in New York that unless the patient is in the active dying process, visitation is not being permitted. And so in order to prepare for an unexpected separation from your loved ones, we're recommending that you fill out what we call a vital information form. The vital information form that we've designed asks you to summarize certain key information that you'd want to have readily accessible to healthcare professionals or to next of kin if your loved one winds up going into the hospital and being separated from you. Certain routine information such as the name, the address, a description of what types of medical conditions the person has. Do they suffer from dementia, hearing loss, blindness, high blood pressure, etc.? Are there any allergies to food or medications? Insurance information, of course, contact information for next of kin, and whether or not the person has signed certain legal documents, such as a power of attorney, living will, healthcare proxy, or last will and testament. I've advised my clients, of course, that if I prepared any of these documents for you and you don't already have them in digital form, contact me immediately and I will email these documents to you so you can download them to a thumb drive or access them readily through your smartphone if they're needed. There's also a place on this vital information form for a listing of prescriptions, vitamins, and supplements. Very important form. The other form that we're advising people to complete at this time is called a critical packing list. Some of these items you would want to bring with you in the hospital regardless of pandemic. But now, especially with these unexpected separation from loved ones, it's all the more important to bring with you everything you think you might need. Items that people might not ordinarily think of are extra batteries for your hearing aids, copies, whether paper or digital, of advanced directives you've completed, and also if you have a pacemaker, a port, or a pump already in your system, bring with you in your critical packing bag the booklet or a piece of paper that describes the brand and model number of this device, so that if the doctors need to know that information, they have it readily available. I'm going to speak very briefly about advanced directives, because if you fail to plan, you plan to fail. I think I learned about that in Weight Watchers, but it really carries over to all areas of life, including the pandemic that we find ourselves facing today. A living will is a document that you would complete if you want to indicate in advance to your loved ones that in the event you find yourself in a situation where you are virtually comatose or unable to act in any way, and the doctor believes that there is virtually no chance of you ever recovering a quality of life, then you do not want your body to be hooked up to artificial means of respiration, hydration, nutrition, etc. If those are your feelings, you may wish to sign a living will. A healthcare proxy is another document you may want to direct now, you may want to sign now. There are special forms of healthcare proxy depending on your religious background. For example, we have a special form we use for Jehovah's Witnesses, but all healthcare proxies are an opportunity for you to name an agent who would make medical or healthcare decisions for you in the event that you're unable to make these decisions. An advance directive is an opportunity for you to direct now for a future need. So you would name the person now who you would want to act in the future if you're unable to make medical or healthcare decisions for yourself. Regardless of who you name as your agent, and we always suggest that you also name a successor agent in case the primary agent is unable or unwilling to serve for some reason, it's important for you to recognize that even if you have completed a healthcare proxy, as long as you yourself are able to make medical decisions for yourself, your agent will not be called upon to make any decisions for you. You are always the person who the healthcare team, your doctor, will look to for answers, as long as you have the capacity to provide meaningful responses. Another advance directive that we strongly recommend is a power of attorney form. Very important. It's not as important as the living will or the healthcare proxy in my eyes, because it relates to money and finances rather than life and death and health. But nonetheless, it's very important. Through a power of attorney, you name an agent, and again, we always recommend that you also name a successor agent in case the primary agent is unavailable or unable to serve. We advise you to also give your agent the broadest possible powers under New York state law, because it's difficult to know now what powers your agent may need to exercise in the future. So those are three of the advanced directives that we strongly recommend that people fill out: the living will, the healthcare proxy, and the power of attorney. A fourth document that is generally a part of a good estate plan is a will. And sometimes you hear people saying, oh, all I need is a simple will. Well, in my experience, simple wills often cause more problems than they solve. And the types of forms, the types of wills that you can easily download from a website, a do-it-yourself kit, in certain situations, I'm sure they may work out just fine for people. But there are so many cases I'm aware of, especially as a surrogates court litigator, where these simple self-made wills cause more problems than they solve, that I do strongly recommend you seek out the assistance of a trusts and estates attorney rather than downloading what somebody refers to as a simple will for yourself. Also, you know, as I was talking to Zahra in preparation for this webinar just the other day, we were discussing that in order for your will to be compliant with Sharia law as well as New York State law, there is absolutely no online simple will form that we're aware of that could take the place of a real will prepared by an attorney with knowledge of both Sharia and New York State law. These are the topics that I had planned to briefly discuss with you. I know that I touched on quite a few areas because I wanted to make sure that you had a knowledge of some of the significant changes made in various areas of the law. The final thing I'm going to mention has to do with guardianships, however, because this is another area as an elder law attorney that I work with frequently. And just like other matters, only emergency guardianships are being entertained by the Supreme Courts today. Pending matters are moving along at a slow pace with video conferencing, but new matters, new guardianship matters, are not being entertained unless they are seen by the court as being emergency. So if you have a loved one who you believe needs a guardian because they no longer have the capacity to care for their personal needs or their property management, or both personal needs and property management, feel free to call me and we can discuss whether or not your matter might qualify as an emergency guardianship proceeding or not. And even if it doesn't qualify as an emergency matter, and for that matter, even if the estate that you need to have opened doesn't qualify as an emergency estate proceeding that the courts would entertain today, it would be well worth your while to get the ball rolling and start preparing these petitions so that when the courts do reopen, your attorney is ready to file right away on your behalf, so that you'll be at the beginning, at the front of the crowd rather than at the back of it. Thank you very much for your patience, and I'm looking forward to hearing what my co-panelists have to share with you today.
Hi, Annabelle. Thank you. That was great. To jump off of a little of what you said, wills and advanced directives are not a one-size-all type of document, one-size-fits-all type of document. I know it's tempting to go online and try to find a cheap, simple will, healthcare proxy, living will, but especially for certain faith groups, it's not going to serve your purposes. So I can't speak for other faith groups, but I know for Muslims, let's say you have a healthcare proxy, it's going to address things like artificial nutrition, you know, when to pull the plug essentially, when to intervene with very invasive life-saving maneuvers that you know, may or may not be compliant with their religious beliefs. Sometimes it's important to work with a lawyer and somebody who is a leader, an imam, a sheikh, who can weigh in to see whether that's something you would want. A lot of times people don't understand the legal jargon, so they don't understand what exactly they're agreeing to. They just think that I have this, I think I understand what it means, but in a life and death situation, it's going to become critical what you've written there. And also when it comes to wills, it is the last thing that you're doing on earth. What you want to make sure that the will that you have is executed properly so that everything that you want to happen will happen. And there's a lot of differences between Sharia law, Islamic law, and New York law. So where something may default to New York intestacy law, it may be in contradiction to Islamic law. For example, a spouse in Islam may be receiving 1/4 of their other spouse's inheritance, whereas in New York it might be 50,000. Half of their property, a lot more than they are actually entitled to. So it's important to speak to somebody about what you want, and also to speak to a sheikh and imam to make sure it's compliant with your religious beliefs. To move on, I'm going to discuss rent, foreclosures, and also some of the changes that have been made to immigration law. So as of March 16, there's been a 90-day moratorium by Governor Cuomo that's essentially halting evictions in New York. Most of you are aware of that. What some of you are not aware of is that a halt on evictions is not a cancellation of rent. So your rent is still due. You're supposed to be paying it if you're able to pay it. What that means essentially, because rent has not been canceled, it means that they can still begin their eviction proceedings by serving you with a non-payment notice. What precedes an eviction is a non-payment notice, so they have to, when you're no longer paying, serve you with a non-payment eviction notice, so that in essence, when the court opens up again, they'll be able to evict you more speedily than they would if they were able to serve you at a later time. There has been, so Representative Ilham Omar, she did introduce a bill to essentially cancel rent and mortgage payments for the year. And in this bill, what would happen is that for the next 12 months or for the duration of the coronavirus pandemic, rents would be canceled, mortgages would be canceled, and there would be an emergency relief fund for landlords to take care of that. If that happens, fine. If it doesn't happen, some things that you should know. So if it happens that the courts reopen and your landlord is intending to evict you, you should know that anybody who has co-signed with you may also be bought in to either fulfill their obligations, or they may be implicated as in they have certain obligations towards the landlord. If that's the case, they do have a number of defenses that may come up both for tenants and guarantors. We suspect that either some of the defenses that are going to come up is force majeure, constructive eviction, impracticability, or frustration of purpose. Essentially, the argument that's probably going to come up is whether, because this was an act of God, a natural disaster, if you will, whether people who had financial obligations towards landlords, towards each other in businesses, still have those obligations. We don't know yet whether that's going to be a valid argument, whether it's going to work, whether people will still have their same financial obligations, but I suspect that that's going to be the primary issue when the courts reopen again. Okay, so some of your rights as a tenant, you cannot be evicted at this time. You also cannot be harassed or discriminated against because you or your family has COVID-19. If you're being discriminated against, if you're being harassed, you can call 311 or you can also contact the NYC Commission on Human Rights. They will intervene on your behalf. They should also continue to make any repairs that you need. If you find yourself in an inhabitable situation, the court still is considering emergency petitions. If you're being locked out of your house, the court will intervene on your behalf. So don't be afraid to reach out and try to get intervention on your behalf. I have gotten calls from people who think, who have run into similar situations. They've reached out to the Attorney General. They've reached out to the Human Rights Commission. They get calls back. So don't think that you're not important enough, or that situation is not important enough for you to get intervention on your behalf. Additionally, Section 8 tenants, they can go ahead and apply for rent reduction if they're not able to afford their rent. They will also get automatic extensions if it's about to be terminated. Any terminations are not going to go into effect at this time. Hold on one second. Okay. All right, so I'm going to move on to foreclosures. When it comes to foreclosures, right now, there are no foreclosures or new foreclosure filings going into effect. But if you find yourself in a situation where you're unable to pay your mortgage, what you should do is you should reach out to your bank and try to refinance or modify your payments. If they're willing to do that, that's fine. If they're not, and you start defaulting on your payments, what's going to happen is you're going to get a 90-day notice. It's a statutory requirement that you are that they give you 90 days notice that you are defaulting on your payments. Usually part of your mortgage agreement, you'll receive a 30-day notice that you're in default. You'll have an opportunity to cure the default. Most people can't cure the default because obviously there's a lot of money that's being owed at one time. If you have 4 people living in the house, if you have a 4-person family living in the house, by New York state law, they will have a mandatory settlement conference to try to come to a resolution. What will happen essentially is that a court referee will be appointed to mediate between you and the banks. It's a good idea to bring an attorney at this meeting to come to essentially an equitable solution. Sometimes the numbers just don't add up. The income is not enough for a modification. In that case, if they haven't reached any kind of settlement agreement, it will go to the court. And also, I mean, the banks will consider and take into account whether the person is elderly, whether they have young children, that sort of thing. So, don't think that they're so harsh as not to come to a settlement. If it does go to court, what the bank will do is that they'll make a motion for order of reference. And again, the court will appoint a referee to try to calculate the amount that's owed by the tenant. What's going to happen is they're going to calculate your insurance, your interest, the payments that are due. After they've come up with an amount, they're going to make another motion to go ahead and get a final judgment on foreclosure for foreclosure and sale. If they get that judgment, they can go ahead and auction the house within 90 days. So and then after that, they'll have 4 weeks to publish a notice in the newspaper, and then it'll be auctioned. And at every step, you will have your opportunity to oppose the motions, oppose what the bank is saying, and also put up any defenses that you might have. And sometimes it's not always necessarily a bad thing to be in this situation. I mean, many people have discovered that there's been issues with their paperwork. Perhaps they're paying a second mortgage they had no idea about. There's a lot of situations where it ends up actually being beneficial for them if you can get If you can get a refinance that's more manageable and you're able to keep your house, you won't be as stressed. You won't have it'll actually make your life a bit easier. Okay, and a final bit of advice regarding foreclosures: make sure you do not ignore any notices that you get. You want to make sure that you respond to everything, respond fully. Try to get an attorney at your earliest convenience or earliest opportunity. Unfortunately, foreclosure defense is not something that has many pro bono attorneys offering their services. A lot of pro bono attorneys don't tend to do foreclosure defense because or they don't want to funnel their resources towards foreclosure defense because it's considered something of a middle class issue. Obviously, the person who's in this situation was able to afford a house. They had enough funds to put down a down payment and make payments at some point. So it's the type of people who get precedence for pro bono funds tend to be people who may be homeless, may rent, may in certain circumstances find themselves unable to get any sort of legal help, be able to afford a house, might find themselves at risk of bodily harm or having their liberties taken away, that sort of thing. But the court does have resources, so don't be afraid to go. Don't be afraid to explain what your situation is. The court does try to help. Okay. Lastly, I would like to go over some immigration changes. So all non-detained hearings are postponed until May 1st. After that, they should be allowing for something like Zoom conferences. Any detained cases will remain open. They have remained open. It will continue to remain, open. Immigration courts are open for filings. They're accepting electronic signatures. You no longer have to have original signatures, and they're no longer accepting extensions at this point. It's possible they may continue to adjourn certain hearings because I personally haven't seen them put together the kind of infrastructure they need to conduct hearings in a fair and neutral manner. Okay. All the in-person services are being suspended. So all your interviews, adjustment of status interviews, naturalization interviews, they're all being suspended until, it should be till April 30. Anybody who has hearings right after April 30 should have received notices when, how they should log into their interviews and how they should proceed. All of your instructions will be in the notices that you get. Biometrics, they're no longer taking biometrics. So if you've already given biometrics, they'll use your old biometrics. If you need to give new biometrics, they're going to postpone it until they have the ability to do so. All reporting requirements have been suspended till April 30. So what that means is if you had to check in with, because you had to check in with the court, you've been ordered to do so, you don't have to do so until April 30. Afterwards, you will, it's likely that you will have to call your local, where you have to check in and check with them to see when they expect you to come back. As of now, ICE is to stay away from houses of worship, schools, and also medical facilities. So they should not be in those locations, but they can still pick you up. So if you're approached by somebody, the same rules apply as applied before. You don't offer any information that you're not asked about. Ask if you're being detained. If you're not, leave. Ask who they are. What sort of police they are. You don't have to talk to them. And if you are detained, if you do get picked up, don't sign anything, don't say anything, talk about your immigration status without a lawyer present. Okay, so that's it for now. I'm gonna hand it over to Delilah. Okay? All right, thank you.
Thank you, Zahra and Annabelle, for inviting me this afternoon. It is my pleasure to be here today. And I am an attorney, not in New York. I'm in Miami, Florida, and I practice in the areas of credit card litigation, bankruptcy, and immigration. I am going to talk for the next 15-20 minutes specifically about what to do if you're unable to pay your bills during this time, what to prioritize, what help is out there for your specific situation, what type of assistance there are, and then lastly, I'll briefly touch on bankruptcy options because not everyone should be rushing to bankruptcy just yet. And hopefully not everyone will do it after the crisis is over, but definitely a few tips and do's and don'ts that I recommend many of my clients and many of the people that are constantly calling us during the crisis. So what to prioritize, very important. Of course, your health. So if you need to pay for your medication, please go ahead and do that. Your mortgage payments, if you can make your mortgage payments, I recommend that you prioritize those. Your car payments as well. And I'm gonna go into details of those areas. What things can hold off or you can delay your payments are credit card payments, medical bills that you've maybe made arrangements to pay back, and student loans. That's very important. Do not cash out your retirement accounts. So your 401ks, your IRAs, do not touch those unless it's a last resort that you should touch. Do maximize your cash. So for example, if you have investment accounts like CDs or some other investment instrument, go to those resources first. And of course, always speak with a professional so that you know what are the consequences of going into those accounts ahead of time or before planned. So going to what assistance are there if you're not able to make your payments. I'll start with credit cards. So because those are the ones that I recommend, push down, hold on to your cash and hold off on those payments. But even credit card companies are giving a lot of options. But these options and this assistance, are not automatic. You do need to contact your credit card company and request assistance if your income has suffered because of the COVID-19 crisis, okay? So how do you do this? You can use the number on your credit card, on the back of your credit card, and contact your creditor. Most major credit cards are offering up to 3 months forbearance, so you do not have to pay the credit card for the next 3 months. They will not charge late fees. They will not report to your credit bureau that you're behind. They will report forbearances to the credit bureau, but an interest will continue to accrue. But some credit cards may even hold off on interest. But in order to take advantage of this assistance, you have to request it. It is not automatic. So give them a phone call. A lot of times, because everyone is calling, the wait time is hours long. So a lot of the major credit cards have designed platforms within their website for you to apply for this assistance. So go to the website first and see if you can log in and request assistance through their website, because it may be a lot faster than waiting on the phone for 3-4 hours. But definitely they are offering options. Cars, with respect to cars, and I'm in Florida, and I'm going to try to give this information as general as possible. But here in Florida, for cars, creditors don't need a court order to pick up your car. If you're behind, they go and pick up your car. So it's very important to actively, again, contact your creditor and request the assistance. There are creditors like Chase in leases that are automatically extending your lease. But for the most part, this is also a benefit and assistance that is available, but you have to contact your car company and request those. They're offering 3 months forbearances on many loans. And what they do is they're extending the life of the loan. So they're adding those 3 months to the back of your loan, different from mortgage companies, and we'll get to those. But it's important that you contact them timely. Don't wait till the last minute. If you're going through this crisis now, don't wait till next week. Pick up the phone right now and call your car company, because here in Florida, they'll pick up your car after you're behind on your payments without a court order, whether the court is open or not. So let's talk a little bit about mortgages. There are, and I think there's information in the chat about specific websites, and the one that I'm going to discuss now is regarding mortgages, whether your mortgage is federally backed or is a conventional loan. And there are differences in the type of assistance that you'll receive depending on what type of mortgage or the servicer of your loan. If your servicer is a federally backed servicer, then you again have to apply for this. But once you apply and you are given automatically 6 months of delay or suspended payments if your mortgage is federally backed. So it's very important for you to, there are a couple of websites on the chat that will if you don't know if your mortgage is federally backed, that will help you determine if it is or not. If it is, all you have to do is contact your lending company, and they will approve a 6 month deferment or suspended payments of your mortgage. Also, there is the ability of requesting an additional 6 months, so for a total of 6 months of suspended mortgage payments. But of course, you have to request that additional 6 months within the first 6 months. If you think towards the end of the first 6 months that you still have not been able to get back on your feet, you still have not been able to catch up with your payments or get a new employment or anything like that, you can request an additional 6 months if your mortgage is it's a federally backed loan. Now, what about repayment of these 6 up to 12 months of suspended payments? You are still responsible for making those payments. Many of the federally backed loans are some of the repayment options are to include loan modifications or extension of the loan, of the life of the loan. Again, putting those payments to the back of the loan, which is the best scenario for many people. But you do need to be aware of what kind of relief or repayment option you're signing on to. Even with federally backed loans, you have to understand fully what you're getting yourself into. We've seen it here. We saw it in 2008 after the market crash, and at least in Florida, we saw it as recently as 2017 after Hurricane Irma, where many of these programs were offered, and then at the end of the 3 or at the end of the 6 months, the debtors or the debtors were required to bring their accounts current. So it's very important that you understand what the terms of the repayment are. But with federally backed loans, you have a lot more options, especially that one of adding those months that you did not pay to the back of your loan. That would be the best option for many people. And again, while you're in the suspension of your payments or suspension of or deferment, they will not report to your credit report any late payments. You will not incur any late fees. So there won't be any negative reporting with respect to that. Now, they may report forbearances, and that could affect in the future if you want to refinance your loan or if you want to buy a new house, a forbearance may affect your credit. So we also added to the chat under my name, I believe, a website where you should be checking your credit report. That's www.annualcreditreport.com. Everyone should be checking their credit report all the time, at least once a year. It's free through that website. but especially now, if you've entered into agreements with your credit card company, with your mortgage company, if those agreements are in writing, it's important that and whether they're in writing or not, if you can get them in writing, great. Especially for credit cards, sometimes they may not be in writing, but the mortgage should be in writing, your agreement. Try to get them in writing, and then also check your credit report at least in the next 90 days. And through that website, you can check your credit report once a year for free. So that's important. Now, what about conventional mortgage loans? Those creditors are also offering options, but not as great options as the federally backed loans. As a matter of fact, we still don't know what the repayment options are for many of the lenders. Every lender has a different policy. Again, it's important that you contact your lender and communicate with them if you have the need and if you, in fact, cannot make your payments. I'll give you some information about what I saw happening to many clients in 2008. And again, after every storm here that we have in Florida, unfortunately, we suffer, and the mortgage payments suffer. I don't want to say a lot of people, but quite a few people that could still make their payments wanted to take advantage of the 3 months, 4 months of not paying, without realizing later on that at the end of the 90 days, they would have to come up with the entire amount that they had not paid. A lot of people fell to this trap and didn't understand why. Everybody thought automatically my payments will be put at the back of my loan and I can just keep paying in 4 months like nothing. That was a big mistake. A lot of people lost their property because of thinking that they could take advantage of this benefit even though they didn't need it. So please be very careful. If you can make your mortgage payments, that's the best option. This assistances that we're getting are not in your best interest if you can make your mortgage payments. So conventional mortgage loans are, again, offering a 3-month suspension of your payments, but many are requiring that at the 4th month, you bring the account current. Some lenders are allowing to extend that loan, the life of the loan for those 3 months. Others may open up their loan modification process, which could be very difficult for many borrowers. It will be time consuming, it will be stressful. And a lot of times, unfortunately, we see borrowers going to companies for help that are sometimes non-attorneys, cannot give them full legal advice as to what their best options are, and then get overcharged for these loan modifications that after months and months of waiting never happen. So just be aware that the assistance that the mortgage companies are giving should be, again, your last resort. If you can make your payment, please do that. Regarding federal student loans, those loans that are serviced by FedLoan and Navient have suspended payments all the way through September. Even if you are on automatic payments, those payments are suspended automatically. You don't even have to call. Those are done automatically. Now, even if you made a payment after March 21st or something, you could even call them and ask for a refund if you really need that money, and you due to the COVID-19 crisis. So that's something there that can help you. If your loans are with a private company or with other lenders, you do need to contact them directly and right away, because they also have many programs available to suspend your payments. It's important to get into these programs because, for example, if you're in a repayment plan or if you're in a non-payment then it could affect your future eligibility if you just stop making payments. So it's very, very important that you contact your lenders regarding the federal loans and if it's a private student loans. Also, it will help you. They will not report to your credit bureau if the account has been approved and the payments have been suspended. Okay, so what other things we can expect and we are seeing as assistance to many borrowers and people that have lost income due to COVID-19 is the stimulus checks that a lot of people are receiving. We added a website for retirees and Social Security recipients that have not filed taxes in the last few years. It's on the chat. You can visit that website to make sure that your payment information is there and that you can receive this stimulus check. It's $1,200 for individuals, $2,400 for married couples. Of course, there are income gaps here. So for the $1,200 individual, you cannot make more than $75,000. For a married couple, no more than $150,000 to receive your stimulus check. And then you get an additional $500 per child, so long as you don't pass that threshold of the income. And again, check that website for any retirees and Social Security recipients that are not filing, that normally don't file taxes, to make sure that their information is up to date and accurate. Now, what to do if bankruptcy is necessary? If 3 months from now, we've recovered from the crisis, but you're still behind in your payments. Bankruptcy should be your last resource. And if you decide that may be your option, then I do encourage you to speak with an attorney knowledgeable, an attorney that has significant experience and that has been practicing bankruptcy law for many years. Because bankruptcy is not just filling out forms, just like immigration is not just filling out forms. It is a complicated process, and if the person preparing your bankruptcy or the attorney preparing your bankruptcy does not understand fully the law, then you could get into a lot of trouble. And what people don't know is once you file it, for example, a Chapter 7 bankruptcy, you can't just say, oh, you know what, I changed my mind, I'm not gonna move forward with it. Once you're in a Chapter 7 bankruptcy, you have to move forward with it. You cannot voluntarily just close the case and change your mind. So this is important because if you have filed bankruptcy and then you discover that whoever filed it made mistakes, or you have assets that cannot be protected during the bankruptcy, those assets may be at risk, and you can't just close the case and say, never mind, I don't want to do this anymore. So that's why it's very important to have legal representation, and not just legal representation, but representation from an attorney with experience, whether in New York or in Miami. It's critical that you hire someone with experience. Be aware of bankruptcy petition preparers. They are not attorneys. They cannot give you legal advice, and sometimes are unaware of the consequences of filing specific bankruptcy, and they're unaware of how to protect your assets or what you have. So just be very, very mindful of that. Now, what are the 3 most common types of bankruptcies? We have the Chapter 7 bankruptcy, which is often called a liquidation chapter. And this is the type of bankruptcy that most people think of when they think of bankruptcy. You do not pay any of your debts back. You get rid of most of your debt. This is mostly used for unsecured credit card type of debt. People with low income, not a lot of assets. It normally lasts 3 to 4 months, and it's a pretty straightforward process if you know the ins and outs of the law and are able to protect that person's assets. And assets, we're not talking about, oh, I have a house. We're talking about assets can be defined as very very difficult to understand if you don't understand bankruptcy law. So very important that you speak with a knowledgeable attorney about this. Then we also have The Chapter 13 bankruptcy, which is a personal reorganization, is like a repayment plan. You're paying back some of your debts for a period of 3 to 5 years. We probably will see a spike of Chapter 13 bankruptcies after this is over, because in bankruptcy, Chapter 13 is where we can protect your home. And if you're falling behind on your payments, we can try to save your home through a Chapter 13 bankruptcy. So that will be very important after this crisis. And then we also have Chapter 11 bankruptcy, which is mostly used for small businesses or business bankruptcy in general. I think I've covered most of the areas that I wanted to touch. One last area that we discussed before, the panelists and I discussed before getting into the meeting today, are what is happening with the with courts in general here in Florida. It's a little bit different from what Annabel and Zahra are describing in New York. Here in Miami, the state court has remained open and bankruptcy court has remained open. Of course, everything is now moving towards telephonic and electronic meetings, nothing in person in court for the most part, but the courts have remained open, the clerks have remained open, creditors have continued to file new lawsuits against debtors and borrowers as this moves forward. With respect to foreclosures, there has been a moratorium on foreclosure, final hearings and judgments and sales, but not on filing of cases. So cases have continued to be filed. Up to a couple weeks ago, we were aware that many process servers were not actually serving the lawsuits. So the lawsuits were being filed, but no service of them. So they really had not started. But as of last week, many of these lawsuits are now moving forward. Process servers are serving the complaints. So the courts have virtually now adapted to the changes and have moved forward with the changes. So please be aware of that and don't just relax. Make sure that you're taking the steps that we've given you today to prepare to get through this crisis. And of course, if you have any additional questions, we're happy to respond to those. I think we all added to our chat notes there our contact information. We'll be happy to answer any additional questions that you guys may have, but I think that's all I have for today.
Okay.
Thank you.
1 second.
I did want to just add something. I thank you both very much for what you shared today. I got a lot out of it, so I'm sure our audience did as well. I wanted to add to something that Zahra was saying about the foreclosure matters being suspended. The Nassau County Bar Association has for years now offered a mortgage foreclosure clinic, and they generally allow clients to come into the Bar Association once a week to meet with an attorney who specializes in that area and to sort of get a good head start on how to handle that type of a matter. The mortgage foreclosure clinics are postponed for now. However, if anybody in Nassau County has a mortgage foreclosure issue, you're still welcome to contact the Nassau County Bar Association. And if you go on their website for the Nassau County Bar Association, they will provide you not only with an email address for somebody you can contact directly, but you can also call the Bar Association. They give you a phone number. I'm not going to say it out loud because I think it's easier for people just to look it up. So there is emergency assistance still available by the Bar Association.
Okay, Delilah, I wanted to ask, so after somebody has filed for bankruptcy, how is their life affected? So, you know, in the long term, are they able to overcome it? That sort of thing.
Well, that's a question that I get all the time. And this is what I tell clients. If you're already considering bankruptcy, your credit is already bad. So bankruptcy is just giving you an opportunity to start all over, to restart your credit, basically. So with respect to how bankruptcy affects your life, specifically your credit report, your credit score, it really will help you clean out all the bad reporting, all the missed payments that you have, all the balances that you have. It will help you clean that out and help you restart your credit, reestablish your credit history. Your credit history is just it's what creditors use to really judge you, to decide if you're a person that's going to pay back or not. Bankruptcy gives you the opportunity, if you fall in hard times like now, to clean out all the bad reporting that you've received in the last years, and give you the opportunity to start again right after your bankruptcy is done, especially a Chapter 7, which will last 3 to 4 months. Basically, you'll start getting credit card offers again. And it's important to rebuild your credit to use it again. A lot of clients, and
I mean that they'll start getting credit card offers 3 to 4 months after bankruptcy.
Yeah, after bankruptcy, you don't even have to wait that long. The moment your bankruptcy and your debts are discharged and all your balances are down to 0 on your credit report, you start getting credit card offers in the mail again. Of course, you're looking at credit card offers where the interest rate is 24.99%, and the amount of credit that they're giving you is low, maybe $300-500, because initially they want to see that you're able to pay these debts back. So it's important to pay those credit cards on time. It's important to pay them in full, so no minimum payments. Those will not help you. And it's important to, if you can, maybe divide your payment on 2 times a month. That will help increase your credit limit faster, and that will help your credit report. So after bankruptcy, creditors, there is no law that you cannot have credit after bankruptcy. Every credit company, every bank that you go and ask credits from has their own policy and is going to decide what type of borrower they're going to lend their money to. So you could go to Bank of America, and Bank of America may say, you know what, if you file bankruptcy in the last year, I'm not going to give you credit. But if it's been a year and a half, I'll give you this credit at this interest this month. You may go to Wells Fargo and say, you did bankruptcy in the last 6 months, I'm going to give you a credit card at this interest rate, at this level. And if you can prove yourself, maybe in 6 months from now, I'll up it. So every bank has a different option. So life after bankruptcy is definitely a possibility. It's one of the reasons why we file bankruptcy. We want to help the people that are following a hard time to pick up themselves again and start over.
Okay. Okay, so I think that'll conclude it. I don't think anybody has any questions. Thank you. Thank you, Annabelle. Thank you, Delilah. Thank you, everybody who's attended. Okay. All right. Bye, guys.
Bye now. Thank you. Stay home, stay safe.
Okay. You too. Everybody stay safe. Bye.